COSIS does submit for your kind attention. I kindly request.
Then why the court should adopt a lower standard in respect of the environment as a
examples of testimonies tied to the human rights impacted by climate. For young people, the demand for reparations is crucial for justice. We have inherited a planet in decline and face the grim prospect of passing on an even more degraded world to future generations. Equally clear is the demand for immediate cessation. If greenhouse gas emissions are not stopped, we are not just risking our future, we are welcoming its demise. As a call for pity or favor, instead they are a united call for fairness and justice. Our campaign for an ICJ advisory opinion was born out of a frustration with the inability of the COP processes to deliver urgent climate action. Recognizing that current efforts fall woefully short of what the world desperately needs, despite repeated warnings and overwhelming scientific evidence, even the most basic progress remains elusive. My colleague and friend Cynthia Honuhi said on the first day of these proceedings, it is not too late to course correct. 5 years ago, in a classroom in Amalus, Vanuatu, where this campaign began, young people dared to take on the impossible, taking climate change to the world's highest court. Today, we have completed that task. We have laid before this
knowledge and cultural identity, and which has left scars of trauma that run as deeply. Under no circumstances can we continue at this volume and rate of access to climate finance for small island developing states and LDCs and expect that they will be able to cope with the magnitude of impacts and loss and damage they are already experiencing, let alone what they are predicted to experience with increasing intensity and frequency of climate change-induced disasters into the future. This presents a blatant injustice to the rights of the most vulnerable.
Mr. President, distinguished members of the court, it is a privilege to appear on behalf. In 2023 at COP28 in Dubai, state parties agreed at a minimum on transitioning away from fossil fuels in energy systems. Building on this consensus, the court could provide valuable guidance by clarifying that the obligations of cessation and non-repetition necessarily require a deep, rapid, and sustained transition away from fossil fuels, because it is too abstract or diffuse, is wholly without merit. This is not even a lex specialis argument. It is states have consented, as they must, to science-based conclusions to protect the environment. Presumably, states have not consented to mass extinction and the collapse of civilization. This is not climate alarmism. It is the stark reality of a temperature increase of 3 degrees Celsius by the year 2100. That is where the current NDCs will take us. The small island states are the canary in the coal mine of climate catastrophe. The major polluters should heed their warning before it is too late, because they too will pay a heavy price. The argument that state responsibility does not apply to climate change because it is too abstract or diffuse is how will future generations look back at these proceedings? This is a crucial moment for the very idea of international law. Narrow state-centric conceptions must give way to the reality of an inextricably interdependent planetary civilization. The climate system does not recognize the artificial boundaries that we have created in our political imagination. There is one Earth, one humankind, and one supreme law that none can escape, which is to live in harmony with nature or to perish.